Aggravated indecent assault is an offence under section 61 M of the New South Wales Crimes Act of 1900. It's where a person commits an act of indecency before, during or after assaulting another person, and it's done in circumstances of aggravation. Now, an act of indecency must have some kind of sexual element, for example, touching of private parts, touching to obtain sexual gratification, exposure before, during or after touching the other person. Circumstances of aggravation are where two or more people were present at the time, or the complainant was under your authority. For example, you're the carer, babysitter, teacher, employer. Or where the other person has what's called a cognitive impairment, that is below average intellectual function. Also, if the person has a serious physical disability, that is something that affects the quality of their lives. The maximum penalty for aggravated indecent assaults is 7 years imprisonment if the matter is decided in the district court. This increases to 10 years imprisonment if the other person, the complainant, was under 16 years of age. If the case stays in the local court, the maximum penalty is 2 years imprisonment. For you to be found guilty, the prosecution must prove beyond reasonable doubt that 1, you committed an assault. Now, the act does not have to be malicious or to have caused physical pain or suffering. It's enough that you deliberately touched the other person without their consent. Secondly, that the assault was indecent. Now, there's no list of what is indecent and what is not. Indecent depends on the ordinary standards of respectable people in the community and can depend on a range of factors. The nature of the act itself, of course, the circumstances of the conduct, your relationship with the other person. However, the action must have some form of sexual elements. Thirdly, that there was no consent. That is, that the other person did not agree to the acts. In other words, did not give conscious and voluntary permission for the act to take place. Now, consent again can be determined through a range of factors: words, actions, the location, your relationship with the other person. And fourthly, that you knew that no consent was given or were reckless as to whether or not consent was given. Now, you must be found not guilty if you honestly but mistakenly thought that consent was given by the other person. This is what's called a subjective test. It's about your state of mind, what you believed at the time, and it's something that can be difficult to determine and depend on a range of factors. Now, recklessness means that the court can look at whether you made inquiries about whether the other person consented or not, and they can see whether or not you were reckless about whether they consented. Fifthly and lastly, there must have been one of the outlined circumstances of aggravation. The defences that are available are consent, where you believe that the other person was consenting; proper medical purpose, such as a gynaecological procedure, pap smear or mammogram; self-defence, where you committed the act to defend yourself or another person; necessity, where you could not help to commit the acts because it was an emergency situation and you had to do something to get away; duress, where you were forced to commit the acts. In our experience, the penalties that you are likely to face for aggravated indecent assault include a Section 10, which means you're guilty but no criminal conviction is recorded against your name; a good behaviour bond, for example a Section 9 good behaviour bond, which is a good behaviour bond that carries a criminal conviction; a suspended sentence, which is a good behaviour bond, but if you breach that by committing a further offence, you will likely be sent to prison; and as a last resort, full-time imprisonment for the most serious cases.